Charles, this was a delay that Yasmin just mentioned that the DA agreed to. He said a 30-day delay. The Trump team wanted a 90-day delay. It was supposed to start supposed to start today, I should say. Yeah. So this hearing, Donald Trump's going to be arguing for it to get thrown out. What do you expect Judge Merchan to do?
I don't expect that Judge Merchan is going to throw it out, although I do understand Donald Trump's attorney's frustration. This is a fair request in terms of the delay itself. Now, to get it dismissed, I don't think is going to happen. I think that Alvin Bragg and his office understands that the SDNY, the Department of Justice, put his office in a very difficult position by giving this document dump as late in the prosecution as they did. So they kind of tied the hands of the prosecutors in this case, as well as the judge in terms of granting the delay this far. But I don't expect a dismissal.
Can you explain the SDNY aspect of this? Because I am so confused by it. I'm hearing differing accounts. I don't understand what the documents were. I don't understand why SDNY wouldn't hand them over. How does Trump's team play into it? Can you lay it out in plain language?
Sure. In New York State, we have what's called open file discovery, which means that if you are a defense attorney, you are entitled to pretty much any and every document, for the most part, that relates or pertains to the case or an investigation connected to the case. It also requires that prosecutors' offices endeavor to make efforts to get whatever documents they can from other offices that are within proximity that would allow them to get relevant information. So even if Alvin Bragg, for example, didn't have the documents, but he knows that the SDNY, the Southern District of New York, and the Department of Justice actually did conduct an investigation and may have paperwork that's relevant and connected to this case, he has to make his best efforts to get those documents and turn them over. We don't know when Alvin Bragg made the request, but we can assume that it was much earlier than those documents were delivered. And basically, the Department of Justice, in a case like this, they operate on their own accord. They do what they want. They don't have to coordinate with local prosecutors to get them information. And it can be very frustrating, as Alvin Bragg's office is likely frustrated now. So SDNY turns the documents over at a very late point. These are a voluminous amount of documents. We're talking about literally tens of thousands of documents that have been turned over from the SDNY's investigation into this very same thing. Things involving Michael Cohen, things involving other witnesses, all of the above. And then all of the parties have to sift through it, which is why we've gotten the delay.
Not to get too much in the weeds here, but the DA has said that there's only about 300 documents that are relevant. If you're arguing on Trump's side in front of Judge Merchan today, what are you saying?
Well, I mean, as a defense attorney, I sort of gravitate towards those arguments, and I'm saying, well, I don't have to take the government's word for it. You know, it's.
I have to go through each document myself, and that's going to take time.
Of course, and you know, in the discovery process, there often are massive amounts of duplicative information. However, you know, this defense team is going to want to cross their T's and dot their I's. The key statutory language that Charles is referring to under the New York discovery laws within your possession, custody, or control. And Trump's team is making this argument a step farther. They're actually saying, well, you know, potentially SDNY and the DA's office are in cahoots, which is actually laughable if you know anything about sort of the history of the relationship between the Southern District of New York and the DA's office.
I mean, they are because they're bad blood.
Exactly. There's bad blood. You know, they are known as the Sovereign District of New York for a reason. They don't play well in the sandbox. Alvin Bragg's memo, which was submitted, which was heavily redacted, did go into sort of the diligence with which he pursued this information. This is the SDNY's issue. It seemed like they had a change of heart on their requirements under the TUI regulations, meaning how they are going to respond to a third-party subpoena. It seems like they messed up there, giving you know, more information sort of on the second round when Trump's team asked for it, as opposed to the first go-around. Alvin Bragg is kind of in the same position as Trump, which I think is why he, consented to the 30-day adjournment. I think ultimately this is going to end up being a blip on the radar screen. I don't think we're going to get the trial date pushed out much past April 15th, maybe towards the end of April, because, you know, there are a lot of documents to go over.
Yeah.
So it's an issue, but it's not
Trump's
like
team wants to throw it out or 90 days.
It's not
the DA said 30 days.
Yeah.
Maybe
60.
It'll be 60 or 45.
60,
all right. So the hearing has begun. Judge Merchan is there. Everybody is seated. He says it's a good idea for us to get started by going over the events that bring us here today and why we're here today. So they're going over the documents.
They're going over procedurally what's happened and basically why these documents got turned over as late as they did. For all intents and purposes, even though it's not Alvin Bragg's fault, Alvin Bragg is the one who's going to have to eat that in terms of eating the time. And what I mean with eating the time is that there's a statutory limitation that requires that cases move forward as quickly as they can, because each of us has a constitutional right and a due process right to speedy trial. Unfortunately, Alvin Bragg cannot push the gas as much as he would like here as a prosecutor, as you want to do, because it's basically the prosecution's fault. It's the people's fault that these documents weren't turned over to the defense, even though Alvin Bragg wasn't in direct possession of them.
So they're arguing a discovery violation. They're trying to get both Cohen's testimony, Michael Cohen's testimony, and Stormy Daniels' testimony precluded from this trial. That would be major. I mean, that would basically sink everything if they were able to do that. Right?
It would, but the judges already ruled on this in terms of the motions in limine. So there have been motions that the prosecution and the defense have submitted about who can testify as to what during the trial, and the judges already ruled on this. So I don't see them going back for any new reason as to changing his mind.
Let us set up what we're actually talking about, the heart of this case. This is a hush money payment that was made to Stormy Daniels in the lead up to the 2016 election. You guys remember, you were watching, there was an Access Hollywood tape that came out in the lead up to the election where Donald Trump talked about grabbing women by their private parts. It was a storm, not to do a pun here, but a storm around the campaign, and there were a lot of Republicans who were backing away quite forcefully from Donald Trump. You had Mike Lee from Utah crying in a selfie video that he posted saying he could never support somebody like this. It looked like the campaign was over. And in and around this time, there was the Stormy Daniels stuff and her talking potentially about an affair that she had with Donald Trump. And so Michael Cohen paid her money. Michael Cohen then later said, after, events unfolded as they did, that Donald Trump told him to make that payment and that Donald Trump would pay him back. There was a payment made back to Michael Cohen after Donald Trump took office. The interesting thing I find about this upcoming trial, whenever it does get set, is that the Access Hollywood tape is not going to be admitted into evidence. Why is that?
So interesting. Judge Marchand is playing it right down the middle here. I think that was a wise choice on his part. He has ruled that it can come in audio or visually. However, they can elicit that testimony. They can talk about it on the stand. It would be, in trials like this, the ultimate question is probative versus prejudicial. He ruled that that type of inflammatory language was more prejudicial than probative.
Okay, but put that in plain language, okay?
Meaning that it's overly inflammatory, and that you can elicit sort of the bare facts of it without actually playing the tape for the jurors, which could, poison their minds against the defendant unreasonably, and not just taking it at the sort of face value. So I think, what's interesting here is that you laid the facts out so beautifully there. That tape goes to the question of, motivation. But, hush money in and of itself is not illegal. Catch and kill is not illegal. The DA's theory of this case here is, misidentification of funds on business records for the purpose of violating a federal election law or New York State election law in the sort of disguise of hiding this money to Stormy Daniels because the Access Hollywood
it's election
tape was
interference.
Yes.
Right, and I think that's a really important point, because I don't necessarily know that Donald Trump is as afraid of fighting this case as he is Fulton County in Georgia, for example, which is another election interference case, or as he is fighting Jack Smith in D.C. And the reason why is that this is a legal theory that requires some hurdles to get through. If you recall, Alvin Bragg had looked at this investigation once before and decided that he did not want to pursue it. What changed in the interim period, we do not know. But it is important to acknowledge that even as Alvin Bragg is moving forward and doing his job as a prosecutor, this is a relatively complicated legal theory, and the longer and the more difficult and more complicated theories are to explain to juries, the more likely it is that you can end up with an acquittal.
How did he get to a felony?
Because of the election interference. That's literally how he got to the felony.
Is there some murkiness there? Is this something that they could potentially appeal on?
Absolutely. Well, not an appeal necessarily, but again, it's a question of, if you're thinking strategically as a prosecutor, have you overcharged in a way that is going to come back to bite you?
Yeah.
That theory of trying to get to the purposes of the election interference, that's where I think there's some vulnerability for Alvin Bragg, and it could mean trouble.